Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Employers are breathing a sigh of relief after the FTC dropped its appeal of a federal court decision striking down its rule banning non-competes. But that doesn't mean that the regulatory threat is over, especially in the healthcare industry. Today, we're hearing from Epstein Becker Green's David Clark, who handles non-compete matters, and also from John Steeren, who works with healthcare employers to give us a full view of the current climate for non-competes. Here's John Steeren.
On September 10th, 2025, Chair of the FTC, Andrew Ferguson, sent out brief warning letters to a number of large healthcare employers and staffing firms, basically urging them to review their restrictive covenants to make sure they're reasonable. There were undisclosed recipients, so we don't know who got these letters, and these were not enforcement actions. And to be clear, the letters did indicate that it understood that restrictive covenants could be pro-competitive, but noted that under certain circumstances, they could have an anti-competitive effect, and urged the recipient of these letters to review their restrictive covenants and to discontinue any covenants that they deem to be unfair or unreasonable. And in particular, to look at the scope that was covered by the restrictive covenants and the duration. The letters do identify certain concerns the FTC has, particularly in the healthcare industry. It points to specifically concerns about patient choice, primarily in rural areas, and the effect that non-competes might have on their ability to maintain their choice of provider.
David tells us what steps employers can take to ensure their non-compete agreements survive challenges.
In reviewing their employees' non-compete agreements, employers should consider whether the restrictions are broader than necessary to protect the legitimate business interests of the company. They may be longer than necessary. They may cover a wider geographic area than necessary. They may cover a larger client base than is reasonable. Employers should consider whether they should revise their non-compete restrictions to narrow those restrictions so that they're laser focused on protecting what really are the company's legitimate business interests. That usually means customer relationships or trade secrets and confidential information. When considering new non-compete agreements, an employer should first ask itself whether this particular employee being hired justifies a non-compete restriction. If that employee is not going to be a very senior person or have knowledge of the company's trade secrets or confidential information or have close relationships with customers, they probably don't merit a non-compete restriction. Employers should also consider other methods beyond non-compete provisions, confidentiality agreements, customer non-solicitation agreements, and trade secret protection audits.
Thank you, John and David. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.